Thank you. Good morning.
Good morning, CJ.
And apologies to you and everybody else again that we could not start on time. Good news is we are correct now and we can begin the business of the day. Premier, I understand that you wanted to say something. You can say it on record.
Good morning, Chief Justice. I sincerely want to apologize. I went to bed very bad yesterday. I was not feeling well, so the alternate agreed to come here, only to find that he's missed his flight this morning, so I was forced to come back to join you. So my sincerest apologies for the delay.
No, thank you, Premier, but I must express my extreme disappointment with you. And it's an aggravated situation because you're not doing this for the first or second time. You always keep us waiting. And that's just unacceptable. And I have said previously that if you are that busy, then just send a representative. You have many people working for you. If one is not, have alternates lined up for you so that this does not happen again.
Indeed, I will do. My apologies.
Thank you. Ms. Strydom,
CJ.
you hold 2 law degrees.
I do.
One, an LLB from the Potchefstroom University.
We were the last class for it to be called Potchefstroom University. The next year it became the University of the Northwest.
Yes. And then you obtained an LLM in extractive industry law in Africa.
Yes, that's a very fresh one. I obtained that one this year. It's mining law, it's extractive industry.
All right. Oh, you just got it this past May.
Yes.
Congratulations.
Thank you.
That's from the University of Pretoria.
Indeed.
All right. In your early life in the job market, you were a research assistant and class facilitator at your university.
Yes, sir.
Potchefstroom. And then you did a few things in London. Then came back and did your articles.
Indeed.
And became an attorney until 2009.
Until the end of 2009. I was admitted in 2008. And then I was an
So
attorney
it
until
was just 1
2009.
year
Yeah.
at the sidebar. And you became an advocate in 2010.
Yes.
At which bar are you?
Pretoria Bar.
Okay.
Pretoria Society of Advocates. It's called.
So it's been 15 years at the bar.
Yes. I was reminded of that the other day. It's been a
Time
stint.
flies. What kind of work do you do?
In the earliest, I've said in my answer, everything, whatever.
The
keeps it
general
boiling.
practice.
Yes. A lot of personal injury, a lot of RAF that predominates our court roles there, but also do medical negligence now, contracts, commercial work, some opposed motions. But predominantly, as I think I've said, 80% is in the sphere of the law of damages, or personal damages, whether it be medical negligence or unlawful arrests or whatever the merits, the damages portion. So.
Okay. So you started acting as a judge from 2019 already?
Yes.
Just short spells. Then you attended the Aspirant Women Judges Program in 2023.
Yes, it's called the Bridget Mabandla program
Yeah.
now, but and I'm quite glad about that because calling it the Aspirant Women Judges program, it seemed as if there was confusion that it was the 2-week course, whereas this one was an 8-month intensive. I won't say grueling but grueling.
Well, it is demanding.
It's very demanding, and we had a very strict taskmaster in our first intro back into the course. I understood it previously was presented in 2007 in a similar format, but yes, no, it was just the most amazing experience, I think.
So you found it useful?
I beg your pardon?
You found it useful?
It changes everything, and I think if anyone that wants to come to be a judge, if the capacity was there, and everyone could be subjected to that type of program, it would be amazingly beneficial for the bench. But I mean, yes, as I said, it does take a lot of time out of one's practice, and you have to really be dedicated to it.
And that
then
has
the
been a
resources.
challenge, actually.
Yeah, and the resources are, you can't, we were 17 people, and the resources just weren't there to sustain it in that format for that long. I mean, it's impossible. But in an ideal world, everyone would have the chance to be exposed to that type of training, especially from other judges. I think that's the most important portion there.
Well, unfortunately, its continued existence has been perilous for a while because
Yes.
there's no money.
Yes.
And the practitioners who leave their practices, who are breadwinners, who have bills to pay, have to get a stipend, and funds have run out, and all sorts of other problems. And we do hope that we'll continue hoping for a miracle, continue getting support so that it does not die.
We had that was at the closing of the function. One of the main issues raised by DJP Mojapelo was about the fact that in our group, at least 4 of us were single mothers, advocates, who had to give up our practices. And it's not just missing out on a trial date. You have to understand the nature of the practice is if I'm out of the running, my attorneys forget about me.
Yeah.
Fortunately, I'm very blessed. I don't have that issue. I've got a wonderful support system in that regard, but a lot of people don't. So stipends would be necessary. Otherwise, you're saying we're uplifting these women, but you're not.
Well, the minister is here, like
Minister.
She in her own capacity and with her network, good connections, will hopefully continue supporting us in our efforts to keep it alive. So you've acted in 2021 as well, 2023, and last year.
Yes.
When was your last stint?
I'm actually currently acting again for this last week, and I'm actually playing hooky today. I'm supposed to be in the civil trial role today, so I'm acting until the end of today. End of this week, not to the end of today.
Okay. So for how long have you acted?
At my last, if I take into account this week, I think the spreadsheet that I sent through to the AJP, it's 36 weeks in total.
36.
Yes. There might be some discrepancies because the early acting stints were those 2019, 2020 were those what we call ad hoc acting stints, pro bonos, and I wasn't keeping as much of a record at that stage as I do now, but it's in the region 34, 36 weeks.
Okay. And in which courts have you sat?
I've sat in all of the courts, save for criminal trials, where as an ACWO court during criminal trials. I have done full court leave to appeals and special reviews, and I'm currently sitting with petitions and bails and things like that. But I've not sat as an ACWO criminal judge. Apart from that, I've not sat in the new family court, but previously under the old format, the unopposed roles, the opposed roles, I did deal with the matters that are now resorting under the family role.
And you've written judgments, hopefully?
I have written...
How many?
I think it was about 42, 40. I did attach it to my CV. When I sent in the form, it was 40. I think it's now 42 or 43. I've delivered... I found one that wasn't on here, and I've delivered another judgment since. So it's 42 now.
All right. And none of them have been reported?
I reported S versus the Swane, which was a special review. I marked it reportable. I tried to find it. I know that on Utah Stats, it's noted as an unreported criminal trial.
The special review?
Yes, and that was just reportable because they were busy with the commission. It's a lacuna in this where the CBI is, that we keep getting the special reviews even when the proceedings were void from the start. The magistrate recused himself. they keep sending these special reviews back to the High Court for us just to order that the proceedings are declared a nullity and referred back, when they shouldn't have been doing so for ages. So that was marked, and then the judgment that I delivered on Monday, I will have also marked reportable, but I'm sure I will be getting.
What is it about?
It's about the common law. Well, it's actually about the very simple common law question is, if I find you guilty of contempt of court in a civil setting and I sentence you to unsuspended punitive committal, whether that translates into you obtaining a criminal record.
And what is the answer?
No. And you don't have to change the common law to get there.
Okay. All right. You are involved in other extra judicial activities. You are quite active in the SACA IWJ. You're one of the mentors.
Yes, I am fortunate enough that I have now, I think this is now the second year that I've been.
Can you just explain briefly what that means, what you do?
So these are typically from the areas, the final year law students, and they essentially they need guidance about where they're going to go in their career. What is the law about? I remember I did not know the difference between an attorney and an advocate until I started practice. So you take them and you train them, you take them with you on trials, you give them guidance on how does one write heads of argument, how does the plea system work, and you just sit there and we have a list of what they should achieve and what the meeting should be about, but the role for me is more that to help these ladies understand where they're going and what they want to do with it, and to show them in a practical sense, this is what, if you're an advocate, this is what you're going to be doing in this. If you're an attorney, this is what you're going to be doing, and this is how it works. And how does one get there? And what do you need to get there? And how do you need to, all these academic concepts that you've now learned, and you're brilliant and you're bright, how does one integrate them on a practical level? Because it's one thing to know what res judicata means. It's another thing to understand where it fits in. So it's very enriching to sit and see maybe a young myself and see how far one comes. So yeah, that's the essence of it. We have meetings. They also have separate training sessions by the organization itself that gives lectures. I find them very instructive for myself as well. It's always useful. So yes, it's essentially that type of a proper mentorship role to take them under your wing.
You are also involved, you're one of the judges in the JSC moot court competitions.
Yes.
You lecture pupils, lecture and mentor pupils.
Yes, that's part of being at the Pretoria Society of Advocates. I've had pupils, and then I give lectures every year on whatever subject they allocate to me.
And you've also listed the subcommittees in which you are involved at your bar.
Yes, I've been involved in quite a few over the years. I don't know if I've listed all of them, but presently I'm sitting on the ethics committee. I used to sit on the Judicial Review Committee for the GCB, but I took myself off that committee for this year, obviously. And then I've sat on the Human Rights Committee as well for Fair Eastern.
Okay. Thank you. AJP?
Thank you, Chief Justice. Good morning once again, Advocate Strydom.
Good morning, AJP.
Your acting stints, you've listed about 36 weeks, which tallies with our records. And on these things, are you able to indicate how many were pro bono, usually the ones that are done during recess period?
Yes, if I look at the spreadsheet, AJP, you would notice that 2019, 2020, and 21, predominantly the recess periods. The ones that I've put in italics, in fact, are pro bono, where I've put it in italics on that form. So those, let's say the pro bono appointments were therefore up until 2021. And AJP, you would recall this is the period when the request went out to the bar for us to assist with these appointments. From 2023 onwards, I've had stipend appointments, and those weren't necessarily in recess. Where those were in recess, that was, I would be, for instance, on the urgent role during a December recess, I recall, or things. So whereas let's say the pro bono appointments, predominantly those ad hoc appointments are to do with the RAF role. From 2023 onwards, where I worked recess, it wasn't as part of that project, it was part of the normal recess work allocated in our division.
Have you also acted in Johannesburg High Court?
I have. I acted there for 2 weeks. I did the urgent role there, and if I recall, I did the unopposed motions. I'll have to double check, but I acted in Johannesburg for 2 weeks, yes.
And according to the spreadsheet that I've got, you've also not sat in the criminal appeals, is that right?
I've not in that sense. I sat in a full court criminal appeal.
Right. Have you done bail appeals?
I did an urgent bail appeal, but just one, and that was also I think that was in Joburg while I was sitting there.
And, petitions from the
I
court?
I have one petition. That was allocated to me this week. I have not completed that one, but I've done special reviews. I've done, I think 1 or 2. And that's the one that I wrote a judgment on. But yeah, the petition is on my desk as we speak.
This training for final year students, for how long have you been involved in this training?
The mentorship program.
Yeah, mentorship by PSA.
Yes, it's not by the PSA, it's by the South African chapter of the International Women Judges.
Oh, okay.
Yes. There I've been involved, this I think is my second year, I'll just have to double check. I've had, yes, so this is my second set of 2 mentees, so yes, it's my second year that I'm involved in that program.
There's another one by PSA. Are you also involved in it? Pretoria Society of Advocates?
For final year students, no.
Okay.
I train pupils for the PSA.
All right. Thank you. You would have seen the comments by GCB.
Yes.
That the appointment may be premature. What's your comment on that?
The problem with the problem, let me phrase it politely. The GCB, I don't know if they have properly perused my application form. JP, you would note that they say, for instance, regarding my appointment, that I've predominantly worked in recess periods, therefore default judgments, unopposed motions, and the like. I'll get to how condescending it is to assume that people who work in recess periods aren't doing proper work. But I mean, factually, that is incorrect. I've not predominantly sat in the default judgment role. If IJP, if you have regard to that spreadsheet, I have spent 8 weeks on the unopposed motion role, of 4 weeks on the, let's call the TIC role, 3 weeks opposed, interlocutories 2 weeks, civil trials 11, special civil trials 1, full court appeals 2 weeks, urgent court 4 weeks. So it's definitely not that I've only sat in recess periods. That's factually incorrect. Since 2023, I've sat in recess twice. So that is just blatantly incorrect. And then the notion that I've only sat most of my periods are 5 days, that again seems to be a reference to those early stints where I was doing the pro bono work, where we were called upon to do 5 days here, because we were doing it pro bono. Since then, after the Bridget Mabandla course, when I started earning stipends, it's 2 weeks, 3 weeks, and then if one wants to use such terminology, then it's proper judge work, then it's not the RAF project. And I'll get to how condescending the terminology of the GCB is in this form in that regard. But doing proper court work. So that assumption is blatantly incorrect. And while I'm on this subject, and I've now alluded to it, I might as well address it front out. The intimation that these ad hoc recess appointments are somehow lesser law, or that the work being done by the judges, acting judges in those types of instances is somehow lesser of importance, I quite frankly, find offensive. They're doing important work. Whether you think RAF is important or not, it's in our courts, and it's important to every claimant, whether it is a TIC. It is a pet peeve of mine, this attitude, and I'm very disappointed that the organization to which I subscribe takes this type of view of those types of appointments. So that is incorrect, yes, sorry.
I agree with you. It is an important job, and the minister also decided to give extra 10 judges so that we can deal with this work. There's also a criticism by GCB in paragraph 9.4. They say that you don't give your own reasons in your judgments. Yes. Can you comment on that briefly?
That case, firstly, that they're referring there to, it's not a judgment, it's the reasons that were asked, and you have to understand the context. That judgment, or that's one of the cases that led to the writing of the judgment that I included in my bundle, the Old Trafford case. And it's essentially, we're sitting at unopposed motion court, and every day we get applications for the sequestration. Body corporates are applying to sequestrate someone because they got a nilla bona in the match court for 30,000 rands, and now they want to take his house. And it's stratagem to bypass the provisions of Rule 46A. It's blatant. But be that as it may, my sister van der Schuyf had written a fantastic judgment in Waterkloof Boulevard. In court, this particular counsel, I took him through his papers, and I took him through Judge van der Schuyf's judgment, and I said, please, in future, look at this judgment. And I even remarked, as he was going out, don't ask me for reasons, I've already given you the reasons. And the next thing, the request for reasons come. So the paragraph they've quoted at the end, I actually do say these are the facts, and they are the same as my sister van der Schuyf's judgment in Waterkloof. But in probability, because I probably should maybe have not explicitly put it like that, but this was the admonition as he was walking out of court was, we've now gone through the exercise, so don't ask me for reasons, and they ask for reasons. So admittedly, when read on its own, it might seem like I'm not giving my own reasons, but I do. She's already written it perfectly. The applications are cookie cutter applications. Why I should write when she has written it much more eloquently. So that's the context of that particular one. It wasn't a judgment. Firstly, it was reasons, and then there's some background there. But then they've also commented on other cases that they've not read. The comment regarding, I think it's Moloi Sane, where they say that I erroneously left in the word insert. It just shows that they simply haven't read it, because in Moloi Sane, it was an extempore judgment that I had typed, and when upon reading the typed judgment, it didn't work in terms of as a standalone judgment. And then I start the judgment with explanation of the rules and where one can insert clarification. And then I set out at paragraph 13, framework for revision in CASI. And then I say the transcript of the extempore judgment and the transcript of the proceedings will be uploaded. Save for the usual editing of spelling and linguistic errors, the removal of interjections and addition of citations, the extempore judgment as transcribed will be reproduced below. and then I say, where the extempore reasoning is obscure and requires clarification or further context, such contextualization or clarifications will be clearly demarcated in italics following the designation insert. So if they'd read the judgment and not just scan through it, they would see the use of the word insert is actually quite pertinent to the judgment. So they have not read this judgment. Similarly with Day, and they criticize me on Day for the Chris Point and then going into peripherals. But if you read Day, I start off in paragraph 3 saying, yes, this is what the Chris issue should have been before us. But as per the norm, they've come with all sorts of technical objections, which form the greatest portion of the argument. Here we go. Let's engage this. It's actually a commentary on the habit of counsel to not just address the clear point, but to take these technical points. And it's not a peripheral for a full court to decide the arguments before it. A point in limine is a point in limine, whether I think that it's ridiculous to take these technical points. You can't not engage with it because the points in limine is raised in Day were the majority of the argument.
So you are saying some of the criticisms are unjustified.
Yes.
I sometimes invite you to come and assist at short notice, and you do come
Yes.
to deal with the matters, and that would also call for you to spend time in preparation. So as far as you are concerned, are you ready to be appointed permanently?
I am more than ready.
More than ready.
I'm chomping at the bit.
Okay. Thank you very much, Chief.
Thank you, AJP.
Thank you,
President.
AJP Premier.
Thanks so much, Chief Justice. I'm covered. Thank you so much.
The next hand, JP Tlaleti.
Good morning, Advocate Strydom.
Good morning, JP.
Yes. The company ADV Karin Strydom Pty Limited, what kind of business is it conducting?
It's me. I pay myself, and then I get a pay slip so that I can, for instance, get a cell phone contract or a home loan. Or it came by virtue of the fact that as advocates, we don't have a company, we're sole practitioners. And when I tried to take out a bond for my house, they're like, do you have pay slips? No. Do you have, in your sole practitionership, any assets? No. And I'm unmarried, so there's also not another spouse. So I pay myself from that account. I pay the pay as you earn, etc. But it's me. I'm the sole shareholder, sole director, sole everything. It is just to simplify it in terms of explanation. When, for instance, really cell phone contracts and home loans, they wouldn't give me a bond because I didn't have a pay slip. My secretary, who gets a pay slip from me, on the strength of that, was able to get a home loan. But yeah, so that's the business it conducts.
How do you define that business in the memorandum?
It's a legal services provider.
Legal services provider. Yeah. Thank you, President.
You, Prof.
Good morning, Advocate Strydom.
Good morning.
I want to talk to you about two cases.
Yes.
In the back of my mind, I know that you wrote the Moloi-Sane judgment. For some reason, I don't get it from your document. Did you refer to it in your in these documents?
Sorry, which judgment?
The Moloi-Sane.
Moloi-Sane, the GPF one.
Yes.
Yes, it's not in yet.
Can we start talking about? Do you still remember it? Because that's the one that I wanted to talk to you about.
I should have stated it. I briefly went through it. It's the one about the pension fund and the benefits. Yes.
Because I just got reminded now when you mentioned it, and I know that I've read it before. So and it's still
Yeah.
very much fresh in my mind.
I should have
Can we-
expected that you would have read it.
Yes, can we
Yes.
deal with it?
Yes.
My understanding in that judgment, it was an anticipation sort of order that was requested, and you had to interdict
Yes.
in the case. And from my understanding, and correct me if I'm wrong, you are dealing with a pension interest
Yes.
and how a pension interest ought to be dealt with. And what I saw, it appeared to me that you dealt properly with the requirements of an interdict in that case. But what appears to me is the same as something that seems to be happening across the divisions in South Africa of the High Court, where there is no proper engagement with the relevant pension law principles that are applicable.
No.
In other words, when one look at the legal framework that governs pension interest, once the pension interest accrue or the pension benefit accrue before divorce, that means the non-member spouse is not entitled to benefit from that as a matter of statute.
Yes.
But perhaps from a marriage point of view, it is something different. But it appears to me that courts are not grappling with that particular position, even though there is a Supreme Court of Appeal case that was written by now Chief Justice Maya, crucial case that gives a platform or a framework as to how those cases should be dealt with.
I haven't read the current judgment. The problem is, and this is especially in Molosani that I was confronted
Yeah.
with, because on the one hand, they're asking me from the interdict perspective to protect something that you don't have. They don't have an interest yet because it hasn't accrued yet.
Yes.
But if they don't approach the court for this protection, for this anti-dissipation type of proceedings, then exactly what you've now referred to happens when it does accrue. Simply the pension fund is dealt with, because what happened, if I recall correctly, and I've said it's been a while, is the respondent, via the grapevine, they found out that he has now resigned from his employer. But they won't even admit that. They won't. So now she's sitting in a position where she knows he's going to dissipate it. She doesn't have that interest yet because the divorce is not settled. So there's a definite, it's kind of a damned if you do, damned if you don't type of scenario. Where,
Yeah, but the problem is this.
Yeah.
In terms of the Pension Funds Act, Section 5,
Yeah.
Subsection 2, it is quite clear that once the fund has received the contributions, those contributions are deemed to be part of the assets of the fund. They don't form part of the estate of the member. So in other words, even somebody comes on an anticipation or interdict, there's no real live sort of interest that they can claim on. But anyway, let's leave that aside because it's a little bit technical. You don't have the judgment with you. I want to ask you about, there's a judgment that you circulated to us, and we've just spoken about that you delivered quite recently, the
Yes.
contempt of court judgment.
yes.
I read that judgment. I looked at paragraph 38 of that judgment, where you articulate what the vexed question is in the case. And then in paragraph 41, you go on to explain the UK position as to how civil contempt of court is actually dealt with in that case, in that country, that it does not constitute a criminal offense. And you go on to say you accept that in South Africa it does constitute a criminal offense.
Is that the, sorry, I just want to get the right
Yes.
judgment. There are two.
The second one.
The second one.
Yes,
okay.
the second one.
Yes.
And then in paragraph 42, you go on to say that there is an uncertainty as to the impact of civil contempt in South Africa. I could not, because when I read the judgment, it appeared to me that your biggest issue there was how should we treat the disobedience of court orders, and should this disobedience lead to a criminal record. I think that was the
question,
fact
yeah.
issue, right?
Yeah.
But I could not understand why is this an issue, because in Zuma 2, both the majority judgment and the minority judgment, to some extent, they do answer this question, that a contempt is a crime, even though whether it comes through civil or criminal, it's a crime. And if you are found to be in contempt, we might argue about whether you're going to be coerced first or you're going to be punished directly. But at the end of the day, ultimately, if you are punished through being sent to prison and you are serving, you have been convicted, and that is a crime. I think the Constitutional Court has answered this question, but it seems like you don't agree that it has.
No, because and that is exactly why this question is, this case has broken me, to be honest. That we started off from that perception, but you'll see halfway through the second judgment, I say, this is what we thought. And I set about saying, okay, initially the query was fine. There's a precedent that if you've got unsuspended punitive sanction, then it counts as a conviction. Okay, but now, at what stage do you become the criminal? Because in criminal procedure, the criminal case, regardless of the sanction, you get a criminal record by way of conviction. In other words, when I make the declaration XYZ committed murder, that's it, regardless of the sanction imposed. So we can't take it that way. Surely the contention's never been that if I give a unsuspended sentence that you now have a criminal record. So we can't use that. That's when we started asking the questions. That was the central premise of the problem statement that I issued in 2024 and that we discussed. And Zuma, IC versus Zuma, this is MK then came back. And I started writing the judgment. Not with whether it's coercive, whether it's punitive. And you'll see in the second judgment, I say, and a wonderful judgment was written. But this is not that judgment, because go and look at where we're getting the terminology. First of all, if you put it here, because and I don't want to step on any toes. IC versus MK, or MK versus IC, depending on which part you were. The court never said anything about a criminal record. The court was interpreting conviction and sentence within the context of the provisions of the Constitution about the eligibility provisions. Similar in the parole matter, conviction and sentence were being used within the context of that act. You'll see the Zuma, I've referred to it now as the Zuma contempt order, doesn't use words conviction, etc., and refers to committal and so forth. And that's, upon reading it, the concept that civil contempt, disobedience of a court order, is a crime, arises from Farki. That's everyone's citing Farki. And you'll see at the start of that first judgment, the introductory paragraph is Judge Cameron in Farki, asking this very question. The very question that I was posed with was asked in Farki in 2007. And that was the start of the niggle. And throughout the remainder of the first judgment, I go through and I trace back exactly what was said. And this is where it becomes important to remember that we have a criminal offense of contempt of court. We have that. S versus Bayer. Civil contempt, but tried in criminal proceedings. Yes? By virtue of the fact that we have, in terms of our Criminal Procedure Act, we have incorporated common law offenses as listed offenses. And I even go through the example of saying, let's call it another name, then it becomes more clear. So there's the criminal offense, contempt of court. That's why I sent the judgment through, because it is quite a lot. There's the criminal offense, contempt of court. And everyone's defined it as a crime, and it's a defined crime. But that is not the same as an offense of a criminal nature. And what you'll see is, in Farki, they're not saying that it is a crime, boop, in isolation. In Farki, they're saying What they've said is because of the criminal nature, we're imposing a criminal sanction. So in civil proceedings, it goes towards, that is why, as a justification for imposing a criminal sanction. It's not a conviction. And where the Constitutional Court and the SCA have in the parole matter and most recent MK used a case law that relates to the prior convictions and determination for the prior convictions, they've been very clear that they've been using it within the context of that act. But you've got to define, if you want to, the criminal records resort under the Criminal Procedure Act. So the concepts of conviction and sentencing must be defined in terms of that act.
Unfortunately, I don't have enough time to take it through, but to say that in the Zuma 2 case, the word conviction appears about
Yes.
28 times.
It does.
And Theron in particular deals with the issue of how conviction impacts the whole thing. And there was no need at all to deal with criminal record. I mean, it follows suit. But anyway, let me leave it there. Thank you very much, CJ.
Could I follow up on this?
Is the follow-up, Commissioner?
Yes,
Mangena?
it's a direct follow-up on this one.
Or the Mangena has his, Commissioner Mangena has.
No, he can go first.
All right, go ahead, Commissioner Gauteng.
Thank you, Chief Justice. Advocate Strydom, if in that native child case there had been a summons for contempt and a trial, would that be a criminal conviction for the purposes of Section 271 of the CPA?
I'm sorry, a summons, and I couldn't quite catch that.
If there had been a summons to attend court
Yes.
in a criminal trial,
So he's been charged.
yes,
There's
yes,
a charge.
through a
there's-
summons, yes.
Yes. Well, then if a criminal court says we find you guilty and we sentence you, that's guilt and sentence as per the various cases that were cited.
No, just please, more specific, would that constitute a previous conviction under Section 271 of the Criminal Procedure Act?
If he was tried and convicted in a criminal court, yes. But that doesn't, but the sentence is irrelevant. For
No, I'm not
purpose-
talking about the sentence, I'm
Yes.
just talking about the conviction.
correct.
Would that be a conviction for the purpose of Section 271?
Yes.
Now, all of the cases then that Commissioner Maruma Okhaya is taking you through
Yes.
say that the so-called civil contempt is a combination of a criminal process and a civil process. And that's why in South African law, contrary to English law, the finding of guilt for contempt is a crime and has the natural consequences of it being a crime.
Commissioner,
But you
that is-
seem to have a different view on that.
Commissioner, that is not what those cases say, with all due respect.
Sorry.
The cases where it says, we're talking about, let's start with Faki, because this is where it's a crime comes from. In Faki, it's quite clear that the justification for imposition of the sanction is the inherent criminality. So there's this distinct difference in terms of, it's not a conviction and sanction.
That's what I'm struggling to understand, because that's precisely the finding of the Constitutional Court.
Yes, the
In,
Constitutional Court's correct. 100% correct.
All right, that's okay, somehow. Anyway, let me ask you a different question. I don't think we have enough time today to
If
discuss
I just
this.
may, Commissioner, it is a very, and I would like an engagement on it. It is actually much simpler than one would think, but that's why, and I apologize for sending that through to late, because one does need to really grapple with the constructs and what was said in an interpretive sense. And that's why I sent through the judgment, but I appreciate that this commission is too busy to have had regard to it. But
we did have
I just want to
regard
make sure. I just want to make sure that nothing in my judgment is contrary to the finding in the Constitutional Court. In fact, it supports everything the Constitutional Court has said, the SCA has said. It's just about the approach. But yes, sorry, I interrupted you about your second question.
Yes. The GCB says that you took a year and a half to give that judgment.
Yes. The second judgment.
Yes.
This one.
Yes. In fact, now you gave that judgment on the, I think, yesterday,
Yes. No,
that you had
on Monday.
on Monday, or well, we got it, I
Yes.
think, yesterday or the day before.
I do explain it in my judgment, and I'm thank you for the opportunity for addressing it because I know what it looks like. Let me start off by saying the judgment between the parties was delivered. I heard them in December. It was delivered in January. My findings, my order, inter parties. This issue of the criminal record, I had raised very remotely and I reserved it. Then because at that stage, the whole eligibility issue was coming to the fore. So then we had the discussion in the June. And as I've said there, at that stage, the Law Commission, and that's what I'd really actually like to engage with you. The South African position and the British position actually aren't different. But the Law Commission was busy with a report. The Victorian Law Commission was busy with their own report. It's taken them 7 years, and I waited for these outcomes. When they finished their reports, I started drafting the judgment that I referred to, and that dealt with all the issues such as coercive or punitive, etc. And that's why in this judgment I say, this is not that judgment, because I was wrong.
No, I'm talking about the second judgment. You
Yes.
reserved that judgment in January 2024. You
No.
gave directives that,
Sorry, I did not reserve that judgment in January 2024.
when you gave directives in January 2024 that parties must address you within 10 days on your problem statement.
That they must file their papers. They addressed me in June 2024.
Not within the 10 days in the
No,
judgment.
they had to file their papers within 10 days. There
Yes,
was
all
an
right.
engagement, and this was a mere motu thing.
All right,
right?
let's work on June. I don't want to quibble with that. Let's work on
Yes.
June 2024. The JCB says it's still a year outstanding at the time they wrote.
Yes, and I considered that, and it is contained in the second judgment. So what's happening here is, as result to the parties, the applicant there was compliance. The respondent had complied. The applicant has withdrawn for all intents and purposes and not taken.
Sorry, Advocate Strydom, I'm sorry. If you could just really be precise. I just want to know the reasons for the delay.
I'm trying to get there.
Okay, well.
The
That's fine,
question
I'm
is
listening.
not a simple question. And we can sit here and we can debate it for the next 2 weeks.
No, Advocate Strydom. The rules are clear. You must give a judgment in 3 months.
I gave the judgment.
And then, yes, but this judgment is reserved from, according to you, you got submissions in June 2024.
Yes.
You've given the judgment only yesterday, on Monday.
Yes.
Now, the rule is that you have to give a judgment in 3 months, and the maximum period is 6 months. And then if you can't do that, you must ask the judge president.
Yes.
That's what I'm asking you about. The JCB says you cannot wait for a year and a half. So what is the explanation?
If I may, the judgment as on the issue that was before me was given. The only question was whether the respondent would have a criminal record as a result of my findings. That I had raised mere motu. And I explained in my report that there was no clear-cut answer, because despite the common perception that it has been decided, it has not. I waited for the reports of the UK Law Commission. I waited for the reports of the Victorian Law Commission. Those came back inconclusive. I addressed it in the second judgment when I looked at the question of delay. As to the applicant had gotten what she wanted, of what they wanted, the company. They'd gotten compliance. As to the prejudice to the respondent, while she was at risk of a criminal record. So there's no prejudice to her to make sure that it is correct. So as between the parties, the justice had already been done. I had raised this point mere motu, and now I have a duty to make sure that I get it right, because I was not prepared to, on the basis of a rule of general application, to make criminals of everyone that's ever been imposed a sanction in a contempt of court proceedings. So the judgment, I've written 2 judgments. The normal course judgment I gave well within the 3 months. The portion that I saddled upon myself, yes, that took longer. But because
But
of
that's
how...
what I'm asking. What is the explanation for that? You say you
And
waited for the research.
Yes, I waited for that report. I waited
When
for
did those come?
the Victorian Law Commission has now postponed it to the end of November.
So they never gave a report.
They've not given the final one. They've got the interim commentaries one. I've looked
When
at
did
those.
that come?
Those, the interim commentaries.
Yes.
And there are several different portions. So I think the last ones that I looked at are also about June. Similarly with the British Law Commission.
All right. So in June already you have the British Law Commission and the Victorian report. But what is the explanation from June up until yesterday?
And that's also contained in my judgment. When I received it, I started writing the judgment. And it was a brilliant judgment, setting out all sorts of very clever concepts. But I was wrong. I was wrong, and I referred to it in the judgment as confirmation bias, in assuming that the Constitutional Court had said, yes, you will have a criminal record.
But the only thing I could see in the judgment is that you were busy researching the judgment and then changing your view as you go along. I couldn't see anything objectively that stopped you from finalizing the judgment timeously.
As I've said, the judgment that I'd written initially was based on the incorrect premise that has now been canvassed, or the incorrect assumption that the common law has, after the Constitutional Court had answered Judge Cameron's question in Farki, which they decidedly did not.
All of those judgments of the Constitutional Court were out by June 2024.
Yes. And I assumed that exactly as everyone else apparently, that it stood for one, in principle, that you would have a criminal record.
That's what happens when you write a judgment. You read the judgment and then you
Yes,
can...
but it doesn't say that.
Sorry?
I
What does it
disagree that it says that.
I'm not saying whatever the outcome.
Yes.
What I'm saying is, though, everything that you needed to write your judgment was available in June 2024.
No.
But you gave the judgment... So what you say was not available in June 2024?
I'm not sure you're going to get the result you need by taking this any further, Commissioner Ngugaitobi.
I stand
I
corrected,
get-
Chief Justice. Thank you very much for the
But
time.
you can continue if you
Yes.
want.
All right. I do, unfortunately. What was outstanding from June 2024?
As I've indicated, in June 2024, we had the meeting, and as I go through Mighty Solutions in terms, of course, of the meeting, we had the matter was argued. I go through Mighty Solutions, and I have to answer, what is the common law? Why is it there? And the position is not clear.
No,
And
I
note
understand
from-
that. I don't have a problem with the method of writing the judgment. I'm not questioning it. I have a problem with an unexplained delay of more than a year.
I'm trying my utmost to explain the delay, to explain why I could not willy-nilly, because I'm now being forced to a 3-month period, make a determination on something as crucial as criminal records. And in that regard, I had to have regard to what is the real common law position. And there were no judgments within South Africa. There was no position in South Africa. The British common law seemed to be at odds, and I needed an explanation, but then why is the British common law at odds? And then I noted that they are busy with their review, and they're busy with their program. And one of the pertinent issues raised in their Law Commission report is that criminal records are still being noted against people for civil contempt, even though in that jurisdiction it's not supposed to happen. A similar issue was raised in the Victorian Law Commission's report. Both of those commissions were intensively looking at that. We have nothing in South Africa. I have to go look outside of South Africa.
Yes,
And I
all right.
waited for those reports. When those reports came in, I started drafting the judgment. I finalized the judgment, and I realized there was such a degree of confirmation bias that the Constitutional Court has decided Section 271 as being applicable in civil contempt proceedings, that we've approached this from the entirely incorrect perspective.
Yes.
And that you
Did
can't
ask
use.
Did you ask the JP for an
Commissioner
extension?
Nugaito, that is her explanation. Whether or not we find it satisfactory is something else, and we can, talk about that at deliberations when you assess her.
Yes.
I think she's
No,
given an explanation.
I stand corrected. I'll stop here.
Yeah. Commissioner Mangen?
Thank you, Chief Justice. Advocate Strydom, one of the key attributes of a judge is good judicial temperament. And the factors to be taken into account, one of them is patience and willingness to be persuaded. I got a sense that you are impatient with, and you were impatient with Commissioner Marumagai and Commissioner Nkweto. Is that assessment correct?
I apologize if that may seem that I would rather, I'm not impatient. It's just that this particular subject and both of the commissioners featured the submissions and the articles that they've written and the heads of argument they've submitted actually featured significantly in this judgment that I've written that has taken over my life for the past year. So if I seemed impatient, it's more because I feel very passionate about this particular subject. And I do apologize. I don't mean to seem impatient. It's more a question of that the very people that I've been having conversations with in my mind for the past year, I actually get to talk with in a live setting. So I do apologize if that seemed, if it came across that way.
Okay. In the answers that you gave to the AJP regarding the comments made by the GCB, you used the words like the GCB is condescending, the GCB probably has not read, and the objections are technical. And I thought that whatever comments that they made them as part of criticism of your judgments and your work as an acting judge. And shouldn't you have seen that as part of constructive criticism and as something that you can learn from instead of being defensive?
As I've said, I've sat on this committee, and I am very, very FA and prefer constructive criticism. The reason in my conversation was, and that's why I pointed out, that they did not read the judgments. It's not me being defensive. If you just look at where they're commenting on the Molasani case or the Molasani judgment, they're saying, I forgot to take out the word insert from the judgment. But the word insert should be there, and if they'd read the judgment, they would know that. Similarly, the day matter, if they'd read the entire judgment, they would know the entire judgment is an ode to a full court's complaint about these other technical points. And then in terms of the condescending comment, I actually stand by it because of the way that they've phrased the default, the recess work being undertaken by pro bono advocates. It doesn't apply to me because they're factually incorrect. I've not spent most of my time in recess, but I think it is condescending, the tone taken, that somehow advocates that take time away from their families and come and act for free to help out the court are performing lesser judicial work than other people. And I'll stand by that comment. It is condescending. So insofar as I'm not being defensive, they're correct. On the, not the Deswani, the Zarambi matter, I probably should not have, in my reasons, I should have put it better. I agree. But don't be factually incorrect. And don't act as if some law is more important than other law. I'm sorry, and if they've taken the time to read my application, I actually went on quite a bit about that it is my pet peeve that somehow it's more important if you do a big competition matter than if you do an RAF matter. And that I'll stand by that, and I will be probably noting an issue with the way they've raised this. Yes.
Thank you, Chief Justice. Thank you, Advocate Strydom.
Commissioner Jivan?
Thank you, Chief Justice. The one case that you cited in the cases that you appeared in on 6.3 of your questionnaire answered, in which cases you have appeared would you regard as being most significant and why? You cited the J.M. Koza versus the heirs.
Yes.
As somebody involved as a property practitioner myself, I find that a common problem, as you cited in your response. What was the outcome? You haven't given us in the summary what was the outcome of that case.
The registration, fortunately, this was in the Polokwane High Court, where the judges perhaps have more of an instinct towards what's happening in the rural communities. It was granted, the occurred, and they duly got the property. And regrettably, it's one of those cases where it would have been great to have an updated judgment, just saying what we already know, because it's apparently the situation is prevalent when one goes into the more rural areas.
Thank you. Thank you. Thank you, Chief Justice.
Commissioner Hassan?
Thank you, Chief Justice. Advocate over here. Advocate Strydom, I also want to ask you about the process of being appointed to the Refugee Appeals Authority in February of this year. Have you already begun that work, or when did you start?
No, so actually we got an email yesterday to give dates for when we can start assisting them. So we haven't started. We did receive, after the application, we did receive our appointment letters from the minister. So, and essentially we work on an ad hoc basis to help. It's similar to what we're doing in the courts, a project to assist to get rid of the backlog. So we've got to give dates now this week for when we are available to come and sit and work through that backlog.
Okay, so I'll ask these questions in a future context. So in my constituency work as an MP, there have been quite a few, in fact, persistent complaints about the backlog. And even this most recent weekend, I had a complaint come to me about the inability to even access the refugee center in Marabastad. So it's a very, very big issue. And these are obviously people from war-torn countries. We know that in the last 2 years, we have seen more conflicts in the world than I think the most recent 50 years or something like that. So we recognize that it's a geopolitical issue. But I'm interested, Advocate, especially now that we're looking in the future, what your plan might be in terms of practicalities to eradicate the backlog, bearing in mind, those real barriers of language, trauma, missing documents, and other precarious legal statuses.
So the assistance of the members of the GCB is actually a proactive step from the side of the minister to eradicate that backlog. And what we have already received is quite invaluable training about how it should be done. Because you have to remember, we're sitting on the appeals tribunal. We're not the port of first entry or the point of first contact. So it does make it difficult. They first got to go on appeal before they even get to us. But in terms of and I found it fascinating the way it's handled. It's not an accusatorial, it's inquisitorial. There are procedures in place for dealing with trauma, for missing papers, so once they get, I'll leave it to this, so once they get to us, they are well catered for. The problem being obviously at the point of first entry, where they've now got to declare that they're looking for asylum. Those are where the complaints are. And invariably, this is now from my acting stints, those we deal with those in court on review mostly. Yeah. So unfortunately, there's not much that we can do as the appeals tribunal. That has to actually go to the, let's say, the point of first entry.
All right, I'll ask this question, I think, regardless, because I am interested in your views. I had initially thought that the process had begun, and so I was wondering, based on some of the experiences you might have had, who else needs to be at the table? You know, do we need the Department of Home Affairs, legal aid, pro bono panels to ensure that backlog is eradicated successfully? And now I am also interested, and I also am interested in the colleagues in the room, whether one can serve on the bench and also serve on this appeals authority.
About your last question, I'm not sure. In any event, these aren't permanent appointments, these are ad hoc. So I don't think that should necessarily be an issue, should I be appointed, but I mean, that we'll deal with. As to who else can be at the table, in terms of the constituting the members of the tribunal itself, that is set by law. In terms of who can help out, so for instance, like the PSA, we've now offered our time, etc., and we're getting a stipend for it. You can get more people involved. The problem just being, where's the money coming from? And what I understand, the biggest problem, the backlog, is that the EU, and I was talking under correction, the UN used to give a substantial amount of funding for the tribunal, which funding has now been revoked. So it's literally just a case of we need money. But I think that's the common theme with all the great projects that we want to embark on.
Thank you, Chief Justice.
No further questions, colleagues? Commissioner Matolo Tlebu.
Thank you, Chief Justice. Good morning, Advocate Strydom.
Good morning, Commissioner.
I just want your response to the LSSA comment. They say she has one reserved judgment, whether she has no reported or appealed judgment, she has no publication in the legal field, she has not held any quasi-judicial role, nor served as a magistrate. Considering her experience in litigation and judicial exposure, she retains qualities required to serve as a judge. However, she will benefit from additional acting stints to accumulate reported or appealed judgments. What do you say to that?
Obviously, one always experience is great, but if the purpose for further acting stints is that more of my judgments can be appealed against, and that somehow subjects to scrutiny, I don't see, I don't quite know how long I'll be waiting, depending on my judgments, I guess. So I don't think it's a well formulated, I actually don't know how to answer that. In terms of how much more experience I need, there might be disagreements about the correctness of my judgments, but I've written widely on various issues ranging from contempt of court to criminal appeals to deciding issues between the LPC and the DEL. I've had that experience, but and I think, and I'm talking under correction, I think a lot also arises from looking at the week's experience and saying, well, we think you should have more experience. The problem just being is it doesn't take into account the 8 months of my life that were dedicated to receiving in-depth training. And I can assure you, for the rest of my career, I will never have that type of training again. I'm not going to be able to have such a course again. So I don't think, I can't wait until all my appealed so that the ECA can tell me how wrong or right I am. The long and short answer to that question.
I mean, the second one, having had the exchange between you and the commissioners, do you think you have patience to sit, to be as judge?
I definitely have. Anyone that's appeared before me, I've listened. I listen long and I listen to the entire argument, and I listen even if I'm being criticized for the day judgment, but they engaged in very lengthy debates about issues that actually weren't mundane. But I listen to them and I entertain them, and I go through the trouble of writing a full judgment on them, even on the leave to appeals, where I am passionate about subject matter. I can become impassioned, but not as a judge, as especially on this. If you're talking about the exchange of the contempt of court, it's simply because this is, for the past year, my child is so tired of this case that he doesn't even want to look at the products anymore. But I'm definitely a patient person with everyone that's appeared before me. And I don't think that there would be any comments to the contrary thereof.
Thank you, Chief Justice.
Anyone else, colleagues?
Thank you very much, Chief Justice. Good morning, Advocate Strydom.
Good morning, Minister.
I noted, which I'm quite impressed, I noted your work around mentorship and also your participation in moot court. Maybe just take us through part of why you've decided to be part of this and your experiences out of it.
Well, moot court, I don't know if I should admit it to everyone present, but I wasn't necessarily the best student when I was doing my LLB initially, until I was part of the moot court group that went to Washington and did the JSC. And it changed everything. It made law this beautiful, beautiful thing. Anyway, so then we move on in years, and the previous JSC contestants get invited to sit as judges and to assist in that sense. And the answer is of course. And it's very rewarding to see how clever the current students are. I can't recall us ever being that clever. So I've sat once or twice as a judge. Unfortunately, during COVID, usually what happens is we sit, it's supposed to be a live session, but we had to do them online. And depending on what goes forth from here, I'm hoping to go and sit in on the live sessions as a judge there as well. So it's there. I've not done it's not a mentorship part of the program because I'm sitting as the judge in some of the rounds for the JSC competition.
On your mentoring, you're currently mentoring 2 legal practitioners?
They're students.
Or they're students?
Okay. So I have, in terms of the Black female counsels that work with me, I'm not mentoring them. They're quite clever. They're working with me, and I'm assisting them in terms of skills transfer or handing over briefs to them. One of them's acted as my junior. I think last month we were in Polokwane with the trial. So that's a separate issue to the formal mentoring positions are with the South African chapter of the International Women Judges, and mentoring in terms of the Pretoria Society of Advocates. These are colleagues of mine who are junior to me, who I'm assisting with skills transfer.
No, that's commendable because we quite raise it quite often about the need for mentorship, but also for appointing juniors as senior advocates so that there is that skills transfer. So it's quite important that we continue because we're talking about transformation of the sector. But from your point as well, talking about that, in terms of the work that you do, how do you see access to justice and also the work? Yesterday or the past few days, we've heard about advocates and legal practitioners who are talking about lack of briefings, especially for female practitioners. And therefore that actually continues to perpetuate the inequalities. Your views on that?
It's very difficult for me to say that I'm not being briefed because I'm a woman. Might be that they just don't like me. I've seen it happen to juniors. I've seen it happen, regrettably, to friends of mine. I've been very fortunate. Obviously, as I've gotten more senior, I have a core of supportive attorneys, but it does happen. And I've obviously been told not to engage specifically, but it's all fine and well. We have these beautifully now transformative rules that you must brief this and you must brief that. The problem is, and this is I do RAF. There is no way you can justify costs of two counsel. So what I do with my matters is they're not briefed per se as my junior, but I would do if there's the merits are simple and it's a separated trial. They would come in and they would do that for their own account. Likewise, if it's an unlawful arrest matter and the merits are difficult, I would do the merits portion of the trial and then stand back and let them do the quantum. And we each say it's costs of one counsel, but we do separate work and the client only pays costs of one counsel, if you understand where I am. Because it is true. You have to in court, if you want costs of two counsel, you have to justify it. That's the practice. So I understand when my colleagues are saying we can't afford costs of two counsel in our practice. That is quite correct. But that does not mean that where you get a brief that is because your attorneys like you, is in actual fact one that is far more befitting someone more junior, that you should then hang on to that brief at all costs just to make money. If you know of a deserving candidate, there's no reason you can't, as I've done now with one of my attorneys, ask him to pull in this junior and first work with this junior so that they're at a level that the attorneys are comfortable with him, and then to step back and to say, listen, I'm still here, but you handle that side of the work. I think that's the only other practical way we can actually draw people in and assist them.
Commissioner Pillay. Thank you, Chief Justice. Good afternoon, Advocate Strydom.
Good afternoon.
I just want clarity on the answer you gave the Minister now before I put the questions to you that I intended to. Are you saying that you don't bring juniors onto your matters in the ordinary sense?
No, I do. I have just, in September, I had, in the proper sense, I was the senior and she was the junior. But that case, I could justify the cost. In other words, when we win, which we will inevitably, it's part of it, but when we win, the state will have to pay costs of two counsel and we can recoup costs. What I'm saying is, it is in the sphere of the type of work I do, it is rare that a case is that complicated that would justify that. But that does not mean that you're excused. You sit back and say, well, I can't help it, my work is not enough. If you get briefs in that are that simple, then this junior, for instance, the junior that now sat with me is one of the juniors that has come up from my attorneys, from that incentive that we're training her up, and invariably she will be at a level where I can quite comfortably say, my attorney, I've seen this brief on this matter, I think maybe she should rather take it. We're comfortable with her progressing like that.
You're saying in your field of work, it's rare for you to have the opportunity to bring on a junior?
Yes. Where you get, if you do RAF work, if you do a lot of damages, unlawful arrests, remember, if your client, RF is a bit different, but your client has to pay. So your clients are usually indigent. So how are they paying for two counsel? They can't even afford one counsel. It's not that the work necessarily is that simple. It's that your client is not a bank or a big government entity that can afford to brief seniors and juniors. Some people just have to get by with what they have.
Right, now to the questions that I wanted to raise with you, and I'm going to put the problem statement to you, Advocate Strydom, and then perhaps get your response generally, and if necessary, we can go into the specifics. I was listening to your critique of the GCB in relation, I think, to your Moleisani judgment. You said that you thought that they didn't read your judgment because they didn't pick up what the insert means where you used it. Isn't the problem a different one? Isn't the problem that you adopted a very complicated way of dealing with this? You handed an extempore judgment, comprehensive judgment, and then later decided that you wanted to either add on or supplement the judgment. And that's why the poor GCB is left with a judgment which, to be honest, we haven't seen before in this environment, where you've got a judgment and then insert, and then trying to figure out, well, why is this insert here? Is it a substantive change that should have been in the initial extempore, etc.? So it's a complication that you've created through the mechanism you used.
Two parts to that. When I said they haven't read it, it is simply because they say, oh, it should have been taken out. They don't say it's because it's complicated. They say, obviously, as in my secretary left it there in error, it should have been taken out. As regards to the format that I used there, and I've discussed this with quite a few senior judges as well, and I've been critiqued from either side about the approach that I've taken there. All I can say is, as part of our training course, we have to start thinking about judgment writing in not new ways, but you can't just follow the tried and tested. And the reason why I employed that was to make sure that it's clear that I'm not changing anything on the extempore, because I did not want a situation where between the lines I'm reading things into the extempore that weren't there. So that's why I wanted it to be clearly delineated. Here is what the extempore as is, and this is, the additional, so that there's no confusion that somehow I'm changing
I
those.
accept that, Advocate Strydom. I think where the difficulty comes is when that moment presents itself, you're either ready to hand down an extempore judgment or you're not.
Yes.
Which touches a move. If you opting to, at that stage, hand down a fully substantive extempore judgment, that's it, that's your judgment.
As I said, I've looked at it, and I don't like doing extempore judgments. I think that's probably one of my only extempores. One of few, and it was the first time I encountered it. But Commissioner Marumokga raised it, that whole issue regarding the pension interest was so important that I did not want the extempore, the way the extempore read, if you take away the inserts, and you take it out of context, and they put this on Safli, it's going to be that acting judge said X. And I could not have it be presented in that manner without the necessary context in which it was said.
And that's
Looking back at it now,
that's why
I just would have avoided
it shouldn't have been an extempore.
No, I'm in total agreement with you. I just could not let that go out under that perspective.
In defense of the tried and tested, and as we understand the tried and tested rules or principles around judgment writing, it's keep it simple. And in fact, the judges have a little acronym, I think it's called IFILARO or something to that effect, which ensures consistency in your judgments. Now, I've looked at your judgments, and it struck me that you use very complicated imagery, for example, in your judgments. More often than not, in fact, I think almost all your judgments start with a quote, and then you try to make the quote relevant to the issue you're dealing with in your judgment. And I think sometimes what end up doing is you complicate the judgment to such an extent that it's difficult to follow exactly what happened. Can I just finish the point and then get your response? I'm particularly concerned about the St. James de Chantal Home judgment. You use very complicated imagery there. What troubled me is that you had an unrepresented person involved in that matter. So I just want to get your comment on that.
That case, and AJP is sitting here, that case has become a rite of passage for every acting judge in the division. The judgment's quite long, and I've set out there. I couldn't even trace all the people.
Advocate Strydom, I read the judgment, so I know how complicated
So,
the issue is.
and you'll see there that I say, yes, they're unrepresented. They're not unrepresented. They're representing themselves.
Yeah, well, they were representing themselves.
And you know, they've been representing themselves in this matter since before the respondents' counsel had been admitted. So they're not quite.
But please, if you can just address the issue of substance that I'm putting to you, is that the judgment uses such complicated imagery and you sustain it throughout the judgment.
Yes.
That the issues get completely lost. So I only picked up three-quarter way into your judgment, what the application before you was. For example, you add at the beginning of the judgment, add a whole lot of parties on. Then you've got a footnote that says, these are not cited as parties, they're here to demonstrate how complicated the matter is, etc. So it's those kind of tools which I'm saying renders the whole judgment so complex.
That judgment, I'm glad if you could find out what the application before me was, because it was a frankenbug of applications. But I take your point on the complexity of the imagery. What I can say is, I think that's also a 2023 judgment. A lot of the judgments where I have employed that type of judgment writing style were done during my period we were doing the training, the British Mabanda training, and we were being challenged to not follow IFILRA, to think and write judgments from a new perspective towards the people. So the St. Charles and James case is an absolute. If you saw the notice of motion, you would understand my reticence to say what the actual application before me was, because there wasn't. It was they put everything into one. But some of the other judgments, and I do take your point, are very, say, poetic or complicated feature. But that was whilst in that period I was writing, I was being trained on judgment writing, and we were being challenged to not just follow IFILRA, to write judgments that matter, to write judgments that impact people. So in that period, maybe I could have taken it too far, but that was all part of the process of not seeing judgment writing as a mechanical process of X, Y, Z, etc., but seeing judgment writing for what it is, and it being a proper tool that you have to address towards the people, towards the parties. So yes, but I do take the point that it does get long. And St. Charles the James was, it's a very different type of matter. The parties that were cited there were cited by the applicants. What they would do is they would bring an application, and then the respondent, whoever the respondent is, this advocate they would invariably lose. So the next round, when they come to court, that advocate would also be cited as a criminal, as a this, as a that, or the judge is a this, or so the out end of St. Charles the James is that it's absolutely an abuse of process. What was happening there? But I do take your point that during that period, I might have been having too much, tasking myself too much with exploring judgment writing.
Sorry, just a final question for me. You're aware that on the 9th of August, the judiciary adopted its sexual harassment policy.
Yes.
Have you been through the policy?
Yes, we had to, before we were sworn in now, we had to confirm that we've gone through it. I've not picked through it with a fine-tooth comb. In some extent, it greatly resembles what we already have at the PSA and other companies that I've worked with. Yes, I've seen it.
And your views on any challenges or hurdles to implementation of the policy?
Policy should be implemented, and I'm glad that there are structures for reporting. So I don't think there are challenges per se with the implementation. The challenges with any sexual harassment policy is changing the perspective of the victims. Because you can create all the structures in all the world. If the victims are still scared to come forward because of that negative connotation that invariably attaches, it's going to be a very pretty empty space. But in terms of the implementation, it should be implemented. I can't believe that that such a document hadn't existed previously. But yes.
Thank you, Chief Justice.
If you didn't go through this policy carefully, as you say you didn't go through it with the fine-tooth comb, but it was something you had to acknowledge, being aware of during taking, when you were sworn in. What were you signing to?
No, when I say I didn't go through it with a fine-tooth comb, is I'm aware of some comments about the issues regarding some of the definitions. I didn't go through it with a fine-tooth comb as in I now have to set out whether or not the definition, for instance, of one incidence of sexual harassment constitutes an actual series of harassments, etc. But then I read it, I'm aware of what it says. I'm just not going to sit, I wasn't asked to expose on whether it's right or wrong. To me, it seems perfectly in order. As I said, it's on par with what we've had for a while now.
You are aware that you are bound by each and every clause in that document?
Yes. I just know that there are some issues that have been raised regarding the definition about, what is one instance of sexual harassment, when is it a repetitive pattern, etc. But I mean, that is not for me coming in as an acting judge to be taking up writing it. But of course, I see myself bound by each and every single clause contained.
Okay. On the issue of your writing style, as was raised with you by Commissioner Pillay, I will just tell you that in my many years on the bench, the one important lesson I've learned about that exercise is to write as crisply and as simply as you possibly can, so that anyone who chances upon that judgment, even a high school child, ordinary person who can read the language you've written, can understand it. Keep things simple. That's the trick.
Yes.
Yeah. All right, we've reached the end of your interview. You're excused.
Thank you very much.
Sure.